Good afternoon, everyone, and thank you for attending our webinar today on predatory lending. This afternoon's one-hour interactive webinar will focus on the following issues: definition and examples of predatory lending, the role of the residential mortgage loan broker, the Equal Credit Opportunity Act, full documentation versus low documentation loans, Foreclosure Rescue, mortgage fraud, HR 1728, the Mortgage Reform and Anti-Predatory Lending Act. Jim Lynn is our presenter for today, and he is the principal of the Lynn Group, Incorporated. Mr. Lynn is a qualified expert on consumer and commercial banking issues who has consulted with over 20 community financial institutions. Mr. Lynn is proficient in all aspects of commercial and lending and consumer lending, including credit training. I'm going to turn the presentation over to Jim now. And please, again, if you have any questions, you can submit them through our chat section. Take it away, Jim.
Okay, thank you, Carol, for that kind introduction. Also, many thanks to you and to your colleagues at the TASA Group for sponsoring this webinar presentation today. I'm pleased to have the opportunity to be a part of it. Let me also welcome all of our participants to the webinar. I am pleased that each of you has been able to take some time out of your busy schedules to join us for a discussion on what I think is a timely topic, namely predatory lending. I want to start our discussion today with an overview of lending and then lead into a discussion of what constitutes or what does not constitute predatory lending, specifically what is permissible under the law and what is not permissible. Also, what constitutes normal and customary lending standards and what does not. I also want to dedicate some time to discussing mortgage fraud and its various manifestations and how it has impacted the residential mortgage loan financing industry. And finally, I will present a summary of the Mortgage Reform and Anti-Predatory Lending Act of 2009, which did pass the United States House of Representatives last May by a vote of 300 to 114, an illustration of bipartisanship, believe it or not. It is now pending in the United States Senate, and I think the legislation will provide an appropriate context to how our lawmakers see the issue of predatory lending and how they want to address it. Now, let me go to the first slide, or actually the second slide if I can. I have on your screen there the types of lending, defined commercial and consumer. A commercial loan is the primary use of the loan proceeds is for a business purpose, such as investment in accounts receivable, inventory, property, plant, and or equipment. Any loan to a partnership, any loan to a limited liability corporation, any loan to a corporation itself is a commercial loan. Also, I would add that any loan to a nonprofit entity, such as a church or a school, would be considered a commercial loan. On the other hand, we have consumer loans. And a consumer loan, the primary use of loan proceeds is for a personal, family, or household purpose. For example, a residential home mortgage for the primary residence of the borrowers, a student loan, a credit card, a loan for a personal vehicle, a home equity line, a personal line of credit. They are illustrations of consumer loans. Now, the big difference between a consumer loan and a commercial loan is the regulatory process that impacts not only the underwriting process of underwriting a loan, but also the administration of a loan. A commercial loan is frankly a little bit more free-form, if you will. Now, one other difference here: a consumer loan, a loan could be either a consumer loan or commercial loan, depending on how the proceeds are used. As I said, if you had a residential property, such as a house in an average suburb in this country, and you had a loan on it, if it was the loan was for a consumer to occupy as his or her primary residence, that loan would be a consumer loan. If the loan was for to hold the property as an investment property to rent it out to another person or persons, that loan would be a commercial loan. So even though you have the same house, depending on how the loan proceeds are being used determines whether it is a consumer loan or a commercial loan. Now, let me move to the next slide if I can. We've got some consumer lending standards up there, which are a function of the lending institution's own policies and procedures, as well as various federal and state consumer protection regulations. First issue I wanted to address is loan policy. What is loan policy? Frankly, regulators require financial institutions to have loan policy for each area of lending, which would normally include in a conventional bank, commercial lending, commercial real estate lending, and consumer lending at least. But lending policy, regardless of what area it is dedicated to, is going to be and should be a compilation of best practices that have been learned over a long period of time, as well as incorporating compliance with all federal and state regulations pertaining to consumer lending. Policy provides guidance to decision making. It's not a substitute for decision making. I often liken it to the manual that you get at the Department of Motor Vehicles more years ago than certainly I would care to recall, and I'm sure many of you too. But in any event, when we went down to get our license, they gave you a manual. I suppose it's online now. But it gave you the rules of the road, everything from traffic signals to when to stop for school buses. It doesn't teach you how to drive a car, though. Loan policy is the same way in that it doesn't teach you how to lend money, but it does teach you the rules that give guidance to decision-making in terms of underwriting and administering a loan. The next point I wanted to touch on was evaluating the loan application, and there's several standards in the consumer loan that you look at in terms of evaluating the creditworthiness of a particular loan applicant. The debt ratio, the FICO score, the LTV, the cash after settlement. I know I'm into the jargon now, but I'll get you covered. We'll break it down and walk you through each piece. The first thing I want to do, and what I'm trying to do, is determine whether the loan applicant is able and willing to repay the contemplated loan in accordance with the terms and conditions of the contemplated loan if the loan application is approved. The quickest way to do that, or the first thing to do, is probably obtain a credit report on the individual, a personal credit report, which will give you the person's credit history at least over the last 7 years, and it will tell you how he or she met his or her obligations to various consumer credit grantors. It will tell you how they pay their bills, how much debt is outstanding. It will also give you information on any judgments or other issues that are matter of public record with respect to that individual. So if you know already after you review a credit report that the person would not meet your credit underwriting standards just on that and that alone, the most efficient way to handle the situation is simply to turn down the loan at that point in time and to move on to the next one. Because even if the person may qualify on a debt-to-income ratio and the collateral would be acceptable, you know that if the credit report and the person's credit history is not acceptable to the institution, the loan ought to be rejected at that point. I should say that, and those three criteria are actually four, but the three principal ones, the debt ratio, the FICO score, and the LTV or loan-to-value ratio, you have to, all three have to be acceptable, or else you don't want to do the loan. So the first thing, again, is to obtain the credit report and see what that looks like. The next thing you probably want to do is look at the person's debt-to-income ratio or debt ratio, and that really expresses the relationship between all of the person's consumer debt obligations. That would include monthly payments on all revolving credit, such as MasterCard, Visa, and any store accounts. It would also include the monthly payment that you may have on any installment loans, such as a car loan. It would also include your payments on a home equity line, student loans, and so forth. And last but not least, it would include the payments that you owe on your primary mortgage. What you want to do is take the aggregate sum of all of those payments and compare that to the amount of income that the that the loan applicant has available to repay debt. That will usually be income from employment, but it also could be retirement income. It could also be investment income. Frankly, it could be a combination of all three. But you want to take the ratio of monthly payments, aggregate monthly payments, in relation to the aggregate income and determine what the ratio is. And a prime lender, I would say that if a ratio is 40% or less, that's going to more than likely be acceptable. When you start moving into the 40s, the higher you move, probably the more problematic the loan is for a prime lender. And let me just address on a subprime lending. Also, I might as well inject it here. Subprime loans are loans to consumers who have some credit issues in the past. There could be some income issues. It could be a number of different things, but usually it focuses in on credit issues. A subprime lender will be willing to have a higher tolerance of risk, usually in terms of credit scores and so forth, than a prime lender. So the thing is that if you're a prime lender and you have your debt to income ratio and it's probably going to be 40% or less, the thing is that if the debt ratio is in excess of that, the best thing to do is consider it outside the parameters of your loan policy and to decline the loan. It may, in fact, be acceptable to a subprime lender. But if you're a prime lender, don't make yourself a subprime lender is the long and short. The FICO score is a unique score assigned to each individual. It is a proprietary formula that's owned by Fair Isaac and Company. All of the three major credit reporting agencies, Experian, Equifax, and TransUnion, use FICO scores. And is also shown on each individual's credit report. FICO scores generally range from a low of about 350, I believe, to a high of 850. If a credit score is certainly in the 800s, it's exceptional. I have seen it before. 700 credit scores are very much above average. And if you're in the 600s, it's generally acceptable for a prime lender. I'd say probably the cutoff is in the 620, 630 range, and that can change from time to time. It also can change from lender to lender. If you're in the 500s, you probably have some credit issues, and more than likely that is going to disqualify you from being considered for a prime loan, and you're more than likely a subprime candidate, if anything. So you get the debt ratio and the FICO score. What you have to do is look at that information and you determine whether the loan applicant meets your credit standards or not. If it's not, again, the most efficient thing is to turn it down and to continue to move on. If it does, at that point, and you have a serious interest with your borrower, you'll probably want to evaluate your collateral. The most efficient and normal and customary way to do that is to obtain an appraisal on a house, on the subject property, and the appraisal is done by an independent appraiser that is hired by the financial institution. If this comes through a broker, often the broker himself or herself will hire the appraisal and furnish that appraisal report to the lender. The lender is under no obligation to use that. The lender can obtain its own appraisal report, but then again, remember that each appraisal report usually costs anywhere from $250 to $400, so there's a significant cost involved. But in any event, what you'll do is evaluate the collateral, get the appraisal report, have the appraisal done, get the appraisal report, see if the loan-to-value is acceptable. Generally, in a prime lender, you're probably talking of a loan-to-value ratio of probably 75 to 80%. It may be a little bit higher. On a subprime basis, it's usually going to be as high as 90. I've seen it as high as 95. So, again, there's a little more tolerance of risk for a subprime lender as opposed to a prime lender. And last but not least, cash after settlement. A lot of lenders do use that. They want to know if, especially in a purchase, whether the borrowers will have any money after settlement occurs. And first of all, they want to know if they're going to have any money to make it to settlement, what out-of-pocket costs they may have. And then secondly, they want to know whether the borrowers will have any cash after settlement. So, especially if it's a purchase, whether they have the money to meet any obligations in terms of transition from their previous place of residence to the new home. Next thing I wanted to address is the maximum loan amount. What size of a loan does the applicant qualify for? Assume that you applied for a loan to refinance your primary residence, and the estimated market value of the house is $250,000. Your maximum loan-to-value ratio, which expresses the amount of the loan in relationship to the the value of the house. The maximum loan-to-value ratio, or LTV, would be 80% per your loan policy. Therefore, under those circumstances, you could borrow approximately $200,000 based upon the estimated market value of the house. And we'll just assume, for sake of discussion here, that the estimated market value of the house is the same as the appraised value. Now, assume further that your new debt ratio with the proposed new loan of $200,000 would be 55%, and I'm just using this as just an illustration. But your lending policies or your lending institution's maximum allowable debt ratio per policy is only 30%, and you calculate that the maximum debt ratio, the loan applicant qualifies for only a $125,000 mortgage and not a $200,000 mortgage. The question is, how much money do you lend? And the answer to that is basically very simple. It's the lower of the two. So if you only qualify for $125,000 on a debt ratio, but a $200,000 loan on a loan-to-value ratio, the best thing to do is just lend $125,000 and not $200,000. Now, if you turn that around and you assume that on a debt-to-income basis or a debt ratio basis, the borrower qualifies for a $200,000 loan, but the house appraises for $200,000 and an 80% loan-to-value ratio, the borrower only qualifies for a maximum loan amount of $160,000. The maximum or the amount of loan should be $160,000, not $200,000. So it's the lesser of the two in each case. Now, let me talk about just, I might as well interject here an issue on inflated appraisals, which is something that bedevils the lending industry from time to time. No lending institution has any interest in having an inflated appraisal. Every institution wants to have a fair and honest appraisal done by a competent, licensed, or certified appraiser who is qualified to do an appraisal and furnish an appraisal report to the bank or to the lending institution. Sometimes you'll see that people charge that lending institutions are encouraging false appraisals so they can lend more money and that sort of thing. I have never seen that happen before, frankly. I'm not saying it doesn't happen, but I have no reason to believe that it does. I do know this, that a lending institution that is originating loans, and especially if they are keeping the loans they're originating, wants to have a fair and impartial appraisal done of the property. And on that topic, let me just provide you a website in case you want to check out an appraiser who's doing an appraisal of your property. The website is asc.gov. That's A for apple, S for strawberry, C for cherry. I'm getting the fruit business here. asc.gov, and ASC is an acronym for the Appraisal Subcommittee of the Federal Financial Institutions Examination Council. It's obviously a government website. And on that website, you will see that they have a national registry for all licensed and certified appraisers in each state. And there's a page dedicated to each such appraiser. And it will tell you that whether the appraiser meets the continuing education requirements for appraisers, whether the appraiser is currently licensed, and probably most important, whether there's any derogatory information about that appraiser, any sanctions that have been placed on him or her by an appraisal board in their particular state. So it's a good source of information. I just happened to trip over it about 6 months ago, and I've been a frequent visitor since. All right, let me move up here to go to the next slide here, the consumer lending standards. The primary objective of making a loan, a lot of people always say, let's make some money. Well, that's a good idea, but the first thing I do want to do is preserve and protect the loan principal. That's my depositor's money that I'm lending out to them. I'm doing everything I can to preserve, protect, and defend it. The secondary objective is to earn a fair and reasonable rate of return. So, again, I'm trying to protect my principal, and that's another reason why I'm interested in a good appraisal. The second objective that I have is to earn a fair and reasonable rate of return. Two principles underlying the lending process: marketplace information such as interest rates, terms, conditions, etc., is fully and readily available to all participants in the process. And the second is that all lenders and all loan applicants or borrowers are knowledgeable about all marketplace information and are acting in a rational manner based upon such information in a free, fair, and open market. If you have that, that is good for lenders, that is good for borrowers. It's when the optimum results can be achieved. And last but not least, I think I'll move up here to the next slide. Consumer protection regulations at the federal level. The major ones that I have seen are the Equal Credit Opportunity Act that I've dealt with on an ongoing basis as an expert. The Equal Credit Opportunity Act, the Fair Credit Reporting Act, the Real Estate Settlement Procedures Act, and the Truth in Lending Act. There are others, but the purpose of all of them, both federal laws and corresponding state laws and regulations, is to ensure that the lending process is fair, that it's equitable, that it's non-discriminatory for both consumers and lenders, that there is full disclosure of all material issues and matters, and that both consumers and lenders can make informed decisions. So just wanted to bring that to your attention. And the next, I'm at the Q&A, and I'm seeing a lot queued up here, Matt, so what should I do?
Thank you, Jim. That was really, really informative. And we have a couple of questions here. The first question is, do consumer protection regulations also apply to commercial loans?
Good question. Generally speaking, the answer to that is no. There is one aspect I know that of the Equal Credit Opportunity Act that does apply to commercial loans for small businesses. It's the notification of the loan applicant, particularly the notification to the loan applicant whether if the loan has in fact been declined. But other than that, that I can think of off the top of my head, all other consumer protection regulations are just that, for consumers. And as I said at the outset, that was one of the big differences between consumer loans and commercial loans.
Okay, and we have a second question.
Okay.
What is a subprime loan?
Okay. A subprime loan is a loan that is made to a person who has had some credit issues in the past, whose credit does not qualify him or her for a prime loan. It doesn't mean that they can't qualify for a loan, but the rate on the loan is going to be somewhat higher than a prime loan. For example, in this market now, if you can get a 30-year fixed-rate loan for a residential mortgage for about, I'd say 5% plus or minus, and maybe 1 to 2 points or 1 to 2% of the amount of the loan. A subprime loan, and I'm going to guess a little bit here, is going to probably be a minimum of 8 or 9%. That's been my experience in looking at them. I have seen some that are higher, but there is a higher perceived risk with the subprime borrower because of past credit issues. And anyone who does borrow on a subprime basis ought to have the objective the objective ought to be to rehabilitate their credit as quickly as they can and to qualify themselves for prime lending because the rates will be much lower.
Okay, now, Jim, I have a question from Vincent, and his question is it common or acceptable for a commercial lender to allow or direct a borrower to choose an appraiser?
The answer is no. As I have always understood it, the appraiser is selected by the lending institution itself. If the if the borrower has approached the lending institution. Now, if the borrower has approached a broker and has contracted with a broker to arrange for financing for a residential property, it is often the case that a broker will order the appraisal, and since the broker is acting on behalf of the borrower and soliciting loan bids from several different lenders, not just one, the broker will often provide that appraisal report to each individual lender that he or she provides the application to. Now, again, each individual lender is not required to accept the broker's appraisal report. The lender can choose to have its own appraiser appraise the property. But again, there's a cost issue here because appraisals cost anywhere, as I understand it, from say $250 to $400 each, and it's an issue out there that you got to deal with. But the lending institution reserves the right to hire its own appraiser for any particular loan that it reviews.
Okay, and I have another question from Stephen, and his question is, can you discuss assignments and holder in due course?
Not very well. If I can get back to Stephen on that, I'd be happy to do that.
Okay, we will make sure
we can put that in the queue for further investigation and research.
Okay, we will do that. And Stephen, so we will get back to you on that. And the third question we have in the question and answer section is, are the same lending standards applicable to subprime loans as well as prime loans?
Yes, generally. It's the same process as I outlined before. You're going to look at the debt ratio. You're going to look at the FICO score. You're going to look at the credit report. You're going to look at the appraisal report and determine a loan to value. It's just that the standards for subprime lending are a little bit more, shall we say, generous to the borrower. Well, maybe that's not the right word. They are more rigid in the sense that they, again, a prime borrower is prime credit. Subprime borrower has some issues with their credit, which are going to be reflected on the credit report and so forth. And a subprime enables the borrower to borrow money, but again, it's going to be the borrower is going to have to pay a higher rate of interest because of the perceived risk associated with his or her credit application.
Okay, thanks, Jim. I'm going to close out the question and answer session now.
Okay.
And we will return to the presentation. We will also be taking questions at the end for Jim, so for any of you who have additional questions, please continue to submit them through the chat section. So,
okay.
Jim, turn it back over to you.
Okay, here we go. Go up to the next one. Here we are, the main course. What is predatory lending? I found a definition, a couple of definitions, and I sort of put them together, and here's what I came up with. It's a loan characterized by unfair, abusive, and or deceptive terms and conditions which serve to create a disproportionate and unjustified economic advantage to the lender at the expense and or to the disadvantage of the borrower. A predatory loan transaction is deemed to be fundamentally imbalanced to the benefit of the lender, with the benefit not based upon or justified by normal and rational market factors, circumstances, or conditions. Predatory lending is most often associated with residential mortgage loans, especially with subprime borrowers, but it can also extend to other types of consumer loan products such as credit cards or payday loans. Now, as I discussed before in a couple of slides back, I'm going to go back there again. I looked at the consumer lending standards. I discussed there the purpose of the federal laws and regulations and corresponding state laws is to ensure that the lending process is fair, equitable, non-discriminatory for both consumers and lenders, full disclosure of all material issues. Both consumers and lenders can make informed decisions. The difference between that and predatory lending, we've used terms like unfair, abusive, deceptive, disproportionate, and unjustified economic advantage, and so forth. So certainly predatory lending, by its own definition that we have here, is at variance with the intent of the regulatory process that's already in place, which is one of the reasons why there's been a lot of movement, both on federal and state levels in recent years, to address the issue and the situation. But the question is, while we have a definition of it, these terms, unfair, abusive, deceptive, are subjective terms, and what I think we need to do is to try to determine on an objective basis as best we can what a predatory loan actually is. So with that, let me go to an example. We've got a residential mortgage loan transaction in today's market with the following terms. It's a 30-year fixed-rate mortgage at 12.5% interest with a 6.5% loan origination fee and a 2% prepayment penalty if paid in full at any time within the first 2 years. Is that a predatory mortgage loan? Now, a lot of people will look at that and raise their hand and say, it sounds like it is to me. Some people say, no, it sounds like it's okay to me. But that's a subjective judgment. Let's see if we can put some objectivity to the process and determine whether it is or it is not. Let me go to the next slide. And just to let you know, high rate and high fee loans are permissible under the Home Ownership Equity Protection Act of 1994, otherwise known as HOPA. That amended Section 32 of the Truth in Lending Act, which is Regulation Z, Federal Reserve Board Regulation Z. What is a high rate, high fee mortgage? Well, we know, I would classify mortgages in this respect in two ways. One is normal. And as I described before, in this market, you could get a 5% loan for 30 years with, the total fees amounting to maybe 1 to 2% of the total loan. The question is, how expansive is the definition of normal? And then we get into high rate and high fee loans, but they're permissible. They would be permissible under each state's usury laws. So there's technically, I believe, 50 answers to this question, depending on each state's usury laws. But if we're looking at a high rate and high fee, let's see what we have here. The next example of high rate, high fee, definition of it. For a first lien loan, the annual percentage rate, or APR, exceeds the interest rate on Treasury securities at comparable maturity by more than 8 percentage points. If the loan is a 30-year mortgage, the comparable interest rate is the contemporaneous 30-year Treasury note rate, which can be accessed at the website of the Federal Reserve Board, and I put the website there for your information. Now, in the interest of time, let me save you a trip to the Federal Reserve website, but you may want to access it later. I did access it yesterday, and I found that the 30-year Treasury rate for a Treasury note is 4.57%. The loan we contemplated here, the interest rate was 12.50. So it looks like it is close. Now, having said that, the computation of the APR, or the annual percentage rate, is slightly different than the stated rate. Usually it is higher, and in this case I can tell you it would be. Without getting lost in the weeds and trying to determine this, please accept my representation that on the APR test, as we call it, the 12.5% rate will probably exceed the 8% percentage point threshold that's allowable under the APR test. The APR will probably be 13 to 14%. I didn't do the computation of it, but I just wanted you to know that it was at 12.5%. We were at a stated rate. We were moving towards the outer ridges of what I described before as the range of a normal loan. So let me go to the next part of the test, and that's let me do this for a second lien loan or a second mortgage. The APR exceeds by more than 10 percentage points the interest rate on Treasury securities at comparable maturity. For example, if you have a second mortgage on your house and it's a 15-year loan, the APR on that cannot exceed by more than 10 percentage points the 15-year Treasury rate note, and you can access that at the same website as I cited before. And the other component of the test, determine whether it's a high rate, high fee loan, is what we call the points and fees test, and the total points and fees paid by the consumer at or before closing exceed the larger of $583, or 8% of the total loan amount. and the 583 amount is adjusted annually by the Federal Reserve Board based on changes in the Consumer Price Index. I've never seen the 583 applicable. It usually comes down to the 8% points and fees test. Now, what was included in the points and fees test? Origination fees, documentation fees, loan prep fees, underwriting fees, fees paid to brokers that are paid directly by the consumer to the broker to arrange a loan for him or her. If the loan, in fact, is consummated, the broker will receive a payment according to the contractual agreement from the consumer at loan settlement. That is also included in the fees and points test. Most of those fees and points are taken up by just that, fees and points for consummating the loan. If it's more than 8%, it's a high cost, high fee loan. All right, let me see. If it is a high rate and high fee loan, as defined under HOPA, the mortgage lender must make certain special disclosures to the loan applicant in addition to the normal and customary disclosures such as good faith estimate of settlement costs, the early truth in lending disclosure, etc. Also, certain practices are prohibited with respect to the contemplated mortgage loan, such as you can't have a balloon payment for any loan that has a term of 5 years or less, except for a bridge loan of less than 1 year in which the loan purpose is to buy or build a home. Negative amortization is prohibited. Some person will ask, what is negative amortization? That is when you make loan payments that do not cover the accrued interest from the previous month. For example, if the accrued interest on the loan, on your mortgage loan, is $1,000 from the previous month, but your loan agreement says that you only have to pay a minimum of $700 to make your minimum monthly payment, the $300 that you did not pay will be added to the loan balance, and that's called negative amortization. Your loan balance will effectively increase by $300. What we usually see in most loans is positive amortization, not negative, where with each loan payment you're not only paying the entire accrued interest, but you're also making part of your payment is dedicated towards principal reduction or principal amortization. So negative amortization occurs in some loan products, particularly what we call an option arm. If they're still out there, there's not too many of them, I'm sure. But in any event, let me go back to the script here. The default interest rate cannot be higher than the pre-default interest rate, which is significant. Often you will see that if a loan is in default, it's in arrears more than 60 or perhaps 90 days. There's language in the loan document that enables the lender to increase the rate of interest, the default rate of interest, which is significantly higher than the stated rate of interest in the note. But if it is a high cost, high fee loan, the default interest rate can't be more than the pre-default interest rate. In other words, there is no default interest rate. It's the same rate. Most prepayment penalties are prohibited. There are some exceptions if the lender is able to verify that your total monthly debt, including the subject mortgage loan payment, is 50% or less of your monthly gross income, and the borrower is able to refinance a loan from a source other than lender or an affiliate lender. So there are specific rules and specific disclosures for high-cost, high-fee loans. As long as they are in compliance with the state usury laws, the lender is fine. So in the previous example that we had, I think that it was a high-cost, high-fee loan, not on the APR test because it was only 6.5%, but it was on the stated rate, which was 12.5%, but the APR would have been much more than 12.5%. It would have exceeded 12.57%. That would have put it into a high-cost, high-fee mortgage. It wouldn't be what I defined before as a normal mortgage. Okay, some salient points here that I wanted to focus on. The high-rate, high-fee loan is permissible as long as the lender follows all the special rules and disclosures required under HOPA. What is more typical, clearly with all prime mortgage lenders and with most subprime mortgage lenders, is that the origination and underwriting of high-rate, high-fee loans is not commonplace. In other words, the variance between the APR and the interest rate on comparable Treasury securities is less than 8% for a first mortgage and less than 10% for a second mortgage, and the total points and fees amounts to less than 8% of the total loan amount. And points and fees, some practical consideration, is normal and customary in the in the residential mortgage financing industry, that compensation is directly related to the size of the mortgage loan. The real estate agents are usually paid, total compensation is 6% of a mortgage loan, plus or minus. Lenders are paid points on a mortgage loan, so is a mortgage broker and so forth. But I'm looking at it and saying there's a fixed cost of doing business, and if I had a choice between underwriting a $200,000 loan and underwriting a $50,000 loan, and I was going to make 2 points on either loan, I'm going to make 4 times as much money on a $200,000 loan as I would on a $50,000 loan with about the same amount of effort and the same amount of work. So the compensation system is different in the residential mortgage financing industry, but that's just part of the industry. It's part of the rules by which it operates and has been for a long period of time. Just wanted to point that out, that there is it just runs on its unique rules, as it will. Okay, let me go to the next slide here. I tried to go, other issues. All right, let me roll through them real quickly, and I think we got another break for some questions. The role of the residential mortgage loan broker, so discussing that before, it's an intermediary between the borrower and the lender. The mortgage loan broker, I put in there a reference of the Statement of Policy 1999-1 regarding lender payments to mortgage brokers, Federal Register, which was in March 1, 1999. There's been a lot of controversy about mortgage loan brokers and what they do, what they're required to do, what they should do, what they ought to do, and so forth, and how they get compensated. Mortgage brokers get compensated in 2 ways. One, from a direct payment by a loan applicant to the broker upon consummation of the loan. Often mortgage brokers receive an indirect compensation from the lender called a yield spread premium. Yield spread premium is very controversial, has been for years. This ruling, or I think it was by the Department of Housing and Urban Development, it is accessible from their website, tried to settle that matter. I thought it was really an outstanding demonstration of regulatory process. They had all the stakeholders in there, and this is what they came up with. But in the process, basically HUD was saying, whatever the broker earns, either directly or indirectly, we will judge it to be acceptable as long as the broker can demonstrate that he or she actually earned the compensation and did certain things to make the loan happen for the particular borrower. Some of those things are taking information from the borrower, taking the application, ordering the appraisal, ordering requests for mortgage verification, other loan verification, and so forth. There's about 15 different tasks, and as long as they can demonstrate that they completed many of those tasks, more than 5, I think the rule says, plus, what's the train of thought here? If they can demonstrate that they've done many of those tasks, it will be deemed to be acceptable, and that the compensation that they earned would be justified. That's basically the bottom line here. But it also addresses the issue of the yield spread premium. I'll address that a little bit later. Second issue here, the influence of the Equal Credit Opportunity Act on the origination and underwriting of a residential mortgage loan. Bottom line here is that often, and I've seen this in a lot of cases that I have worked on, plaintiffs will allege that the loan that they got was unfair, that it was not the right loan for them, and so on and so forth. And we've had attorneys who will bring those cases against lenders on that basis. And my answer is, first of all, we provided the financing to the loan applicant based upon what the loan applicant requested of the lender. If the loan applicant requested a 30-year fixed-rate mortgage, the lender provided it, assuming that they qualified for it. But generally speaking, and I think it's more specifically speaking, if the borrower qualifies, or the loan applicant qualifies for a 30-year fixed-rate mortgage, the borrower will qualify for any variation thereof, whether it's fixed or variable. And often you find borrowers in variable rate mortgages, and they come back and bring legal action against the bank saying they didn't fully understand it, and so on and so forth, and that the loan is in fact predatory. And my answer is that we provided the loan based on a non-discriminatory basis, as defined in the Equal Credit Opportunity Act. They qualify for the loan, secondly. And thirdly, they had what is known as the right of rescission, which is a 3-day period after the loan settlement occurs, especially in a refinance, where they could have reconsidered the loan and canceled it for any reason or for no reason at all. So I was just in a case a couple of weeks ago where the attorney was deposing me. Attorney asked, but in a transcript of his deposition with a representative of the mortgage lender, asked why the mortgage lender made the loan when it appeared that the borrowers were when they knew that the borrowers were elderly and there were some health issues, and the person representing the lender simply said, because we're required to do so under the Equal Credit Opportunity Act. You just can't discriminate. That's it. All right, a big issue: full documentation loans versus low documentation loans. What are they? Full documentation is what we've just described before. Excuse me. It is you look at not only the credit score and the credit report. You look at the appraisal. You also look at the borrower's debt and/or the borrower's income. Low documentation loans are a variation of a full documentation loan, and the biggest variation is like how the lender treats income. There are such things as no docs, low docs, reduced docs. They go by a lot of different names, but generally speaking, there is not documentation of income on low documentation loans. Now, clearly, if the lender is not documenting income, the lender is taking a higher level of risk. That's clear. But the higher level of risk is mitigated by generally a higher down payment. You're not going to get 80% loan to value. It's going to be something less than that. I have seen as low as 65 to 70%. So the borrower has a higher investment in the subject property. You will probably have a higher qualifying FICO score, and you'll probably have a slightly higher interest rate. So the lender tries to mitigate the risk by compensating itself by increasing the approval criteria on the factors that which it can verify. And again, they're always going to pull a credit report, and generally, certainly on a low documentation loan, you're always going to do an appraisal. It's just really the verification of income and often the verification of assets. A low documentation loan works very well with persons with complex income scenarios. People who have investment properties, shopping centers, apartment buildings, residential properties, and so on. They come to you with a Form 1040 that is, like 3 inches thick. It's a lot easier to evaluate the loan application of a school teacher or a fireman. They come to you with a couple of pay stubs, and you can clearly calculate what their income is. You can clearly see what their predictable income is. It's much simpler. So low documentation loans do have their place, but the unfortunate downside of that is that the bad guys have also figured that out too. And I've seen a lot of mortgage fraud involving low documentation loans, especially stated income loans, where people's income that's stated just wasn't true. I've seen a lot of appraisal fraud in those types of transactions also. So it is an opportunity, if you will, for people who are trying to circumvent the system for their own personal gain and benefit. It is a problem area, and it is an issue, and it is a source of a lot of mortgage fraud. Next point, Foreclosure Rescue, how financing an investment property can actually facilitate a predatory lending scheme. Often happens when a homeowner who is on the brink of foreclosure, the notice of foreclosure is made in the public record and listed in the legal notices of the newspaper. The bad folks out there read those legal notices, then they often pay a visit to the distressed homeowner and suggest that he or she sell the house to him, rent it back for maybe 18 to 24 months, and then repurchase the house at the end of that 18, 24-month period, usually at a much higher price than they sold it. The person, I've seen it one of two ways. The person will finance it himself by getting a loan, or they will take over the mortgage payments for the existing mortgage payments for the owner/renter, if you will, and then again sell it back to them at the end of 18-24 months. You'll also see what is known as a straw buyer often in these type of transactions, where the bad person will put some good person who has good credit up as the applicant for the loan, and the lending institution is evaluating what it thinks is the good applicant as the actual borrower, but the actual borrower is some people behind the good applicant. It's a real problem. It's a real issue. It's very tough to detect it when you're doing an underwriting, but it does happen out there, and it is widespread. That's all I can tell you. And last but not least, mortgage fraud. Often, as I've sort of indicated here, it's inducing the financial institution to originate and underwrite a residential mortgage loan that it never would have had the whole truth been known at the outset. Sometimes due diligence is a process by which you are trying to ascertain what the issues are in a credit, what the person's credit standing is, and so forth, but due diligence is not foolproof. The folks who are trying to circumvent due diligence do so by identity theft and other means, and the long and short is they induce a lender to make a loan that a lender would otherwise not have made. Okay, let me move on here. Okay, we're back to the next question and answer session.
Okay, thanks, Jim. I have a few questions here for you.
Okay.
The first question is, do these predatory lending principles apply to modifications or restructuring of existing loans?
They can. They can. A lot of them, they can. It depends on the loan. It depends on the situation. A lot of times when you're restructuring or so forth, you can present false information, and if it's accepted as true and it's really not true, it can happen.
Okay. And another question from Vincent. If a lender grants a 90 to 100% loan or with a first and second based on stated income and credit score with no money down, could it be characterized as predatory lending?
It could be. And you really, no money down, no investment in the property, stated income, which may or may not be true. The credit score, we're assuming it's actually the person's credit score, and we're assuming that the appraisal is correct, but that may or may not be true. So it's a situation where, especially in investment property, you got to be awfully careful. You just really got to be awfully careful when you're underwriting those type of transactions.
Okay, and this is our third question.
Okay.
Does predatory lending only occur in subprime mortgage loans?
Generally speaking, that's been my experience. I've heard that it does apply, it does occur in prime loans, but generally speaking, as I'll say in the wrap-up, it targets two types of individuals, unsophisticated persons who have little understanding of financial issues, and borrowers in distress, which I just described before with Foreclosure Rescue. That's where you usually see it.
Okay, and I have another question here from Majid. Can a private lender justifiably rely upon the loan recommendations of a mortgage broker?
There is a contractual relationship between a mortgage broker and a mortgage lender. And also, what I have seen in those contracts is that if the loan goes bad, they are with recourse, which means that the mortgage lender can force the mortgage broker to take the loan. And I was just in litigation on that in the state of California recently, that same issue. So there is a contract. Every contract is obviously different, but one thing I have seen in the contract I have reviewed is the recourse provision where the mortgage lender, if it discovers that there's been fraudulent elements in the process of underwriting, and the lender was induced to make a loan that it otherwise would not have made, there is a recourse provision by which it can induce the mortgage broker who originated the loan to take back the loan. In essence, pay the lender out for the loan.
Okay, thanks very much, Jim. I do have another question. This is from Michael. How are lenders handling situations when the broker inflates the borrower's income on the application without the borrower knowing that it was inflated?
Well, it could be internal fraud. Well, what you have just described is internal fraud. That is internal fraud. And it can happen. I'm not saying it can't happen. My experience in working in this industry, the lending industry, commercial and consumer lending industry for the past 25 years, is that the people who are in it are decent, honest, hardworking folks who play by the rules. That doesn't necessarily mean that it's unanimous out there, and what you just described is a person who is deliberately falsifying information to obtain an approval for a borrower who otherwise would not qualify for the loan, I would assume. It's wrong.
Yeah. Okay. Here's another question. This is from James. Are you aware of pro-borrower groups who audit bad mortgages such as Endless Fraud, Inc.?
No, I've never heard of them, to be honest with you. And the question is, what are they auditing the mortgages for, and what are they doing? Again, all the information on the mortgage is proprietary to the lending institution, so I'm not sure what they're basing the audit on and how extensive it could be and what conclusions they're drawing. But it sounds like they wouldn't have the full set of facts upon which to make a determination. So I'm not sure. I'm not familiar with the group. But I would question whether they had the wherewithal, really, to conduct such an examination.
Okay, I think that, Jim, that wraps up our second question and answer session.
Okay.
So we can turn it back to to concluding the presentation.
Okay, let me roll through the last piece here if I can. It will try to take me about 6 to 8 minutes. HR 1728, the Mortgage Reform and Anti-Predatory Lending Act of 2009. Again, this was passed last May by the United States House of Representatives, and here are the key provisions that I found in this particular piece of legislation. All mortgage originators must make a reasonable good faith effort to determine, one, that the consumer has a reasonable ability to repay the loan at a fully indexed amortizing rate based upon verified and documented information, including the consumer's credit history, current and expected income, debt-to-income ratio, and other financial resources. Just from that, it sounds like the days of low docs, no docs, and so forth are going away. And also, I might comment, a fully indexed amortizing rate, often you'll see in a variable rate mortgage or adjustable rate mortgages that the initial rate is lower than the fully amortized rate. So if you're approving on a debt-to-income ratio and you are, shall we say, lowballing the amount of the mortgage payment based upon the initial rate and not the fully indexed, fully amortizing rate, it will give you a different answer. It will give a more favorable answer, to be sure. What you should be evaluating on is what the normalized mortgage payment would be when the initial period expires, whether it's 3 months, 6 months, or whatever. And that's what this legislation or this provision is requiring you to do. That's a good idea. That makes a lot of sense. But what it's also telling me is that we're doing full doc loans now, and the low doc loans, if this legislation becomes law, are going away. The next piece, the refinance transaction will provide a net tangible benefit to the consumer based upon information known or obtained in good faith by the creditor. Actually, that's a provision that's prevalent in many states right now. I know there's at least 25 states in the United States that have that law on a statewide level, and basically it's designed to curb the practice of what is known as flipping, which is inducing a borrower to borrow money and then 3 or 6 months later come back and borrow again, and 3 or 6 months later come back and borrow again, and each time the borrower is incurring points and fees, and there's no economic justification or benefit to the borrower. In fact, I just saw a loan recently where a loan was refinanced 3 times within the last, I think it was 4 times in 2 years and 3 times in the last year. And there is no justification unless there's some extraordinary circumstance. So they're trying to require a lender to ensure that there is a net tangible economic benefit to the consumer, that the rate is actually lower, that it makes economic sense to do so, and I think it's a good idea. Next thing, yield spread premiums are banned from all mortgage loans. We discussed that before. They're indirect payments from the lender to the mortgage broker. It's been controversial for a long period of time. Mortgage brokers are still want to get compensated for their work. I don't know how they're going to, aside from being compensated directly by the loan applicant or borrower, assuming that the loan is consummated. But it will change the way that mortgage brokers perhaps do business. Another thing that it may change, well, we'll get to that in a minute. It will change the way that they do business. The maximum points and fees trigger for a non-HOPA mortgage loan is lowered from 8% to 5%. We talked about that before. If we had a 6.5% loan origination fee on that, excuse me, on that example that I cited early in the hour, and if that was the case, we did this, on the APR test, we said it was probably over. And it would be a high-rate, high-fee loan. But clearly, if the threshold points and fees trigger was lowered from 8% to 5%, and you had a 6.5% loan origination fee, that will trigger it automatically. If the total amount of the loan transaction for any loan is more than $20,000. So what it will do is force more loans into the high-rate, high-fee category. That will require much more disclosures, and it will prohibit some of those practices that we described before. So if these provisions are made law, clearly the structure of the subprime mortgage industry is going to change. There's no question about that. And finally here, the APR trigger for non-HOPA loans is lower from 10% to 8% over comparable Treasury securities, except that the dwelling is personal property and the loan is less than $50,000. As I described before, it is 8%. It used to be 10%. It was changed in 2002. That was changed by regulation by the Federal Reserve Board, but I guess Barney Frank wanted to help the process along and codify it into law. So he's put his 2 cents worth in there, or reduced it by 2%, and making it part of law rather than part of regulation. And let's see, we also have financing of points and fees is prohibited. That's a change. Balloon payments are prohibited. That's a change. Stronger enforceable standards to support and preserve a real estate appraiser's ability to determine and verify the value of a property for the buyer, the seller, the lender, and the investor in the residential real estate transaction. I want that. I want a real estate appraiser give me his or her honest opinion as to what the value of the property is. And last, the mortgage originator that violates the duty of care will be liable to consumer for the greater of actual damages or amount equal to 3 times broker fees plus costs, including attorney fees. I guess all of our attorneys in the office will like, or in the audience will like that. So just again, passed overwhelmingly in the House of Representatives. It's still pending in the Senate. And just when we wrap it up here, I got a couple of conclusions that I just wanted to cite. As I said, predatory lending targets 2 types of borrowers: unsophisticated persons who have little understanding of financial issues and borrowers in distress. There are resources available out there. There's HUD-approved housing counseling services to guide and assist borrowers. The only problem is there's not enough of them. From a lender's perspective, the best type of mortgage loan, or the best type of any loan, is one that pays in accordance with the terms and conditions of the loan. If the borrower is unable to continue to make loan payments on a timely basis, loan modification or loan restructuring is far more preferable than foreclosure. It's far more cost-efficient than a foreclosure, and that's why. But the best type of loan is the loan that you just send in a check once a month, or even better, you have it automatically deducted from your checking account. They are the most efficient to manage. And last but not least, regulation is proper and appropriate in the origination, underwriting, settlement, and servicing of a residential real estate transaction. Yet in order for regulation to achieve its desired purpose, it must balance the intent to preserve and protect the interests of all parties to a real estate transaction with normal market forces and incentives that motivate each party in such a transaction. And what we're seeing with this proposed legislation is that it's going to impact, in a very fundamental way, the dynamics of the residential mortgage financing industry. So with that, I will turn it back to you, and we're ready for any other questions.
Thank you very much, Jim. I'd like to conclude the webinar today and thank everyone for attending. I know that your time is very precious, so we do appreciate you coming and attending our webinar. If
For your reference, in approximately 1 hour after this event, we will be sending out an email with a link to the archived recording of the webinar. We also do ask that you take the time to fill out our survey that will appear on the screen after the webinar is over. So thank you again, and I appreciate all of your attendance, and please look forward to receiving additional emails from us with announcements of future webinars. Thank you again.
Thank you. Still there?
Yeah.
Still there? Anybody still there? Hello. See. Oh, man.